Hi, welcome to Mondays with Melissa. Today I want to talk about avoiding probate. Now, first, let me just say, in New York, probate isn't necessarily as scary as everybody makes it sound, although things can sit with the courts for quite some time, depending on which court you're in. But probate generally is not as scary as it may seem. Now, when people come to New York from Florida, for example, they always have revocable trusts because probate in Florida can be more difficult. So people use revocable trusts to avoid probate, and we do that here in New York as well. So one of the ways to avoid probate is by putting your assets into a revocable trust. A revocable trust is not going to protect your assets for Medicaid or long-term care planning purposes. A revocable trust is going to be a vehicle where you can still utilize your assets however you want and whenever you want. You can add things, you can take things away, but your revocable trust is going to name beneficiaries. So when you pass away, your assets that are held in that trust are going to pass directly to those beneficiaries without having to go through the court probate process before they can access the assets of the estate. So people like that idea of kind of bypassing the court proceeding and just allowing the assets to flow to the beneficiaries of the trust. Another way to avoid probate is to make sure that all of your accounts are either owned jointly with somebody or they have a named beneficiary, whether that's a payable on death or a transfer on death or in trust for account. So upon your passing, just by virtue of the way the account is held, it will pass to either the joint account holder or it will pass to the beneficiaries without having to go through the court process or the probate process. So either using a revocable trust or setting up the accounts so that they pass directly without having to go through probate are two really pretty easy ways to make sure that the probate process is avoided. What actually brings us more complications is the family home. So many times, if somebody is a single individual and they own the home, so maybe they owned it jointly as husband and wife, one spouse passed away, now it belongs to the other spouse, and they don't put it into a trust, they don't transfer it to anybody or do any planning with it, they're just sitting with that house. Upon their passing, that house is going to have to go through probate. And yes, there are transfer on death deeds now in New York, which have shown to be a little bit of a difficult planning tool. And also for us as elder law and estate planning attorneys, those deeds don't protect the assets for long-term care purposes. So for us, we're always kind of erring on the side of doing the irrevocable trust because you're both planning for long-term care and also putting the asset in trust to avoid the probate process down the road. So there's a lot of thought that goes into it and a lot of planning that goes into it. So it's not recommended to make a rash decision to do this or that to set up your estate plan. Sit down, go over with us. Who are your family members? Who do you want to get what? How important is it to you to avoid probate? What does that look like after we explain the process and how it would work? So the conversation has to be more than just in a vacuum of, I don't want my kids to have to go through probate. So you can always reach out to us with questions if you have more specific circumstances you want to discuss or go over. You can reach out at ConaElderLaw.com. On our website, you can call us at 631-390-5000. Of course, you can always email me at mnegrin@ConaLaw.com. Like, share, and subscribe, and come back next week for more Mondays with Melissa, and we'll see you then.